Hello, everyone. Welcome back. And today we are talking about this case. I know you saw the headlines, $22.5 million. Okay. So, in this case, what we're talking about here is essentially a jury awarded $22.5 million to an employer, not for harassment, right? Not for wrongful termination, but for denying a pregnant employee's request to work from home. Now, unfortunately, this employee never got the chance to bring her daughter home. And the jury found that the employer's actions really had the most devastating role in that outcome. If this is your first time seeing me, I'm Letitia Newby. I'm an employment attorney and an HR executive with over 20 years of experience. So today we are breaking down this case. The verdict dropped on March 18th, and this is a case that I think every HR professional, every manager, and really every business owner needs to understand so that they can make sure that they don't end up in this situation. All right, so let's talk about this. Who are the parties involved? According to the report from WCPO 9, which is in Cincinnati, as well as NBC News, here are the players. So there's an employee of Total Quality Logistics. This is a Cincinnati area freight brokerage company. Okay, they're also known as TQL. This employee was pregnant in early 2021. She had a high risk pregnancy and had just undergone emergency surgery to prevent premature labor. Now, TQL is one of the largest freight brokers in the country. So this is a big company. They have an established HR function, so there's no excuse for what happened next. Here is what the lawsuit says happened, okay? In early 2021, this was in February of 2021, the employee had emergency surgery on her cervix to prevent her from going into early labor. Her doctor discharged her with orders. Her orders were a modified bed rest, limited activity, and to work from home. So on February 15th, she did exactly what she was supposed to do. She went to her employer and she said, I need to work from home. Here's my doctor's notes. And TQL, what was their response? Well, they handed her the paperwork for an unpaid leave of absence. So here's the thing. She didn't ask for leave. She asked to work from home. These two things are not the same thing. Okay. So she went back to her doctor. She came back with a second letter. And this letter said that she could work, but she could only work from home due to her complications. Her manager rejected that one too, said it didn't have an end date, and it said that it didn't have a specific medical reason. Now, that same day, she submitted a third letter. This one explicitly said work from home until maternity leave in July. And the reason for that, and I'm going to paraphrase it because these are from court documents, but it's to prevent further complications of her high risk pregnancy due to increased activity at the workplace. So her manager took that letter, forwarded it to HR with one line, and this is important. The line said, did you want to take it from here? I'm guessing we're not going to approve her for working from home for this long. Let that sit in, okay? That message right there, that's Exhibit A. The manager had already decided the outcome before HR had even had a chance to look at it. According to reporting from WCPO, TQL never engaged the employee in any conversation about the request. So there was no interactive process, there was no back and forth. They just denied it. So the employee was told, come into the office against your doctor's orders, or you can take unpaid leave and lose your income and your health insurance. Now, if we think about this for a second, that's not a choice, that's a threat. And then Here's what I think makes this even worse. According to WCPO's reporting, just 1 year earlier in 2020, TQL allowed its employees to work from home during the COVID-19 pandemic. At least one person on this employee's own department continued to work remotely even after the pandemic. Others worked from home after COVID exposure. So remote work was a possibility. They had done it before. They just weren't willing to do it for her. Now, needing to keep her paycheck and her health insurance because she was pregnant and she needed the coverage, the employee returned to the office. Her husband eventually reached out to the VP over at TQL because he knew this VP personally. And according to the lawsuit, that VP said, and I quote, "Thank you for letting us know you just saved us a lawsuit," end quote. Now, the accommodation was approved almost immediately after that conversation, but by then it was too late. That same day that the accommodation was granted, the employee began cramping and bleeding. She was taken to a nearby hospital. Her daughter was born prematurely at just 20 weeks and 6 days. And unfortunately, her daughter passed an hour and a half after she was born. So, this is an unfortunate situation for all parties involved, but I want to take a minute and really talk about the legal pieces of this case because there are several federal laws that we need to talk about here. The first one, the Americans with Disabilities Act, the ADA. Remember, under the ADA, pregnancy complications that substantially limit a major life activity like working safely can qualify as a covered disability. That means this employee may have had ADA protections, which would have required the organization to engage in a good faith interactive process and provide a reasonable accommodation unless they could show it caused an undue hardship. Now, from what we see here, they did not do that. Working from home is not an undue hardship, especially because they had just let other people do it the year before and even after 2020 when individuals were testing positive for COVID. Number two, the Pregnant Workers Fairness Act, PWFA. We cannot forget about this. PWFA went into effect June of 2023. Now, it was after this incident occurred in 2021, but this case is a perfect example of why it was passed in the first place. The PWFA requires employers to provide reasonable accommodation for known limitations related to pregnancy, childbirth, or medical conditions. Pregnancy, childbirth, or medical conditions. So, under the PWFA, working from home for a high risk pregnancy is a textbook reasonable accommodation. Denying it, especially without engaging in the interactive process, is a textbook violation. Okay? So, and okay. And the interactive process, this is the piece that really kind of surprised me here because under both the ADA and the PWFA, when an employee requests an accommodation, you are required to sit down with them, figuratively and literally. You have a real conversation with them. You ask questions, you explore options, you document the questions, the options, everything, and you engage with them. This employer didn't do any of that. They pre-decided the outcome before HR had even touched it. The manager's email is proof of that. So let's flip this for a second, right? What should have happened? I want HR professionals who are watching this to walk away with something actionable. Step one, when the employee submitted that first accommodation request, this was a trigger. That is when the interactive process begins. Not after the third letter, not after the husband calls the VP, from letter number one. Okay? Step two, don't reject a doctor's note over a technicality. If the note doesn't have an end date, pick up the phone, call the employee, call the doctor's office if you have the authorization. Saying we can't process this because it doesn't have an end date is not engaging in the interactive process. So that was a problem. Step 3. The manager should have never been the decision maker here. The moment the employee submitted that accommodation request, HR should have owned it, not the direct manager, not someone who may have already had some feelings about this employee or even leaning towards the denial. Step 4, document everything. You all, if you've watched my videos, you know I say this. Document, document, document. If you don't have it documented, it didn't happen, okay? I mean everything, every conversation, every letter, every decision point. Not because you're necessarily building a defense, but because documentation protects the employee too. It shows you took their request seriously. And step number 5, consider the risk of saying no. In this case, the VP said, you just saved us a lawsuit. He knew that the organization had messed up, and they still didn't move until a personal relationship had forced their hand. By then, it was way too late. This lawsuit was filed in 2021. The trial was held in 2026. So that's more than 5 years later. Okay. The jury awarded $25 million total. They found that TQL was 90% at fault. And that is what resulted in the final verdict of 22.5 million in compensatory damages against the employer. Now, the employee's attorney stated that TQL had multiple opportunities to settle this case and they didn't take them seriously. And that decision actually cost them $22.5 million. And the cost to the family is truly something that no amount of money can replace. Nothing will replace that ever. Okay? So here's what I want you to take away from this. Accommodation requests are not favors. They are legal rights. And when your employee comes to you with a doctor's note saying her pregnancy is at risk, the answer is not paperwork for unpaid leave. The answer is a conversation. This case is going to show up in HR trainings. It is an example of what not to do because this is a real life example of what happens when you prioritize office presence over employee health. So if you are an HR professional, a manager, or a business owner watching this, take this back to your team. Audit your accommodation process today because the cost of getting it wrong is not just a lawsuit. In this case, it was a life. If this video was helpful to you, please share it because the more HR professionals and leaders understand these laws, the less we can have situations like this happen. I invite you to subscribe, leave a comment with your thoughts, and as always, I will see you in the next one.